All right, good afternoon, everyone. Thank you for joining the November 2024 HOA Forum presented by the Colorado HOA Information and Resource Center. The topic of this month's presentation is board member roles and responsibilities. My name is Nick Altman. I am the HOA Information Officer with the Division of Real Estate. I also have Amanda Lopez and David Donnelly here with me to help moderate our Q&A today. Hi, Amanda. Hi, David.
Hi, everybody.
Thank you. Thanks for joining us.
Yes, so what David said, thank you for joining us and good afternoon.
So just a couple of housekeeping items before we get started. Today's presentation will be recorded and uploaded to the Division's YouTube channel. You can find the link to our channel at the end of this presentation, where you can view other videos about HOA and general real estate topics. To ensure that we can answer your questions as efficiently and effectively as possible, the Q&A feature is enabled for this presentation, which you should be able to see on the bottom of your screen. If throughout the session you have questions, please click the Q&A icon and we'll do our best to get to your question. If we don't get to your question, feel free to send an email to the HOA Center after the presentation. Lastly, the slides and a link to this video will be posted on our website within a couple business days of today's date. All right, as always, we like to start our presentations off with what we do and don't do here at the HOA Center. So the HOA Information and Resource Center was created to provide basic information to homeowners about their rights and responsibilities under the Colorado Common Interest Ownership Act, or CCIOA, which is state law that governs HOAs. The center gathers, analyzes, and reports information through complaints and HOA registrations. We create resource materials, we provide education and online forums. We have a website with information for the public, and we provide an annual report to the legislature. What the center does not do is mediate or arbitrate on behalf of homeowners, board members, or community association managers, nor does it act as a regulatory program. It doesn't investigate or intervene in disputes that arise between homeowners and their associations. It does not act as an advocate, and it does not have an ability to assess fines or penalties. This presentation is intended for educational purposes only and should not be construed as legal advice. A qualified attorney should be sought out for legal advice. All right, so this presentation will focus on the various roles and obligations of HOA board members. Being an HOA board member can be a very rewarding and fulfilling experience if new board members take the time and care in understanding their new roles. In this presentation, we'll talk about what to do if you're just starting off as a new board member. We'll define some commonly seen leadership positions. We'll discuss in detail the roles and responsibilities of the board, examine board member fiduciary duties, and offer some board member basic job descriptions. So let's talk about the duties of board members, or directors rather. So note that this isn't an exhaustive list, but should be a very good starting point for new board members in understanding their roles. Members of associations depend on effective leadership for the benefit of all the homeowners. And in order to be an effective leader, board members must take the time to read their governing documents. In order to make important decisions, you have to understand and take the time to go through your governing documents. It's kind of like playing, I like to draw an analogy of playing baseball. I myself don't know anything about the shortstop position. So if I was put into that position, I would have no idea what I'm doing or how to help my team win. It's sort of similar with reading your governing documents of the association. Next, the board must protect the assessments. And when I say protect the assessments, the board must ensure the timely and predictable collection of HOA dues from its members. This is important because assessments are the lifeblood of the community and allow the board to carry out its budgetary requirements. Next, as a new board member, you should also acquaint yourself with the common elements of the property. You might live in a community where it's easy to identify your common elements, such as a pool or a tennis court. Other communities, though, it might not be so apparent what the board is responsible for maintaining. For example, there might be a crawl space underneath the unit, or the roof and siding could be something that the board is responsible for maintaining. The declaration will define the common elements of the community, and this relates back to reviewing and reading your governing documents. Again, I can't stress that enough, but you would be surprised how many board members write in not even knowing what the declaration or the bylaws are. Another important duty of the director is understanding the characteristics of your community, whether, for example, whether it's Kiowa or pre-Kiowa. Again, pre-Kiowa communities are those communities that are built prior to July 1st, 1992, and are subject only to certain portions of the Kiowa. You'll also want to familiarize yourself with any investments and reserve accounts under management. Many associations have savings and reserve accounts to be used for very specific measures, most of the time outlined in the CCNRs or the declaration. And then lastly, board members must oversee the actions of the community manager. I hear many times from board members who say, well, I don't know how to do this, or I don't know, I thought that was the manager's job, or it is the manager's job. As a matter of fact, that's just simply not true. While many services are outsourced to the community manager, the actions of the community manager ultimately reflect on the board and association as a whole. So all board members in Colorado should become familiar with Colorado association law, beginning with Kiowa and the Nonprofit Act, the Colorado Nonprofit Corporation Act. These two laws are sort of the bread and butter of Colorado association law. They discuss association governance, powers of the board, meeting and notice requirements, what you might see for composition of the board, and many other facets of HOA law. The Fair Housing Act protects people from discrimination when they're renting or buying a home and prohibits discrimination in housing. This law tends to go overlooked and should be reviewed, especially if the board is considering adopting policies around leasing and renting units in their community. The Americans with Disabilities Act, short for ADA, is an important federal law that protects people with disabilities from, in areas that offer public accommodations. And then lastly, local ordinances and zoning codes regulate things like speed limits in your community and how property might be built or altered on a certain piece of land. So in addition to Colorado law, board members should read the documents of their association, beginning with the declaration on top there. The declaration defines ownership of the common elements, as well as sets forth the standards and restrictions which must be followed by all the members. The Articles of Incorporation is the document that establishes or creates the association and provides for the general composition of the board of directors. Your bylaws will include things like notice requirements, election procedures, and the like. And your policies, procedures, and rules and regs typically contain more detailed, clarified explanations of the restrictions and authorities that you'll see in your declaration. So next, let's identify some of the leadership positions, or I guess the leadership positions that most HOAs will have. A director is a member of the association's executive board. And believe it or not, there is a statutory definition of a director. but it's important to know that a director is elected by the members of the association. And then note also that a director is not yet an officer until appointed an officer by the board. And I'll try and maybe explain that a little more later on. An officer is any person to whom the executive board delegates responsibilities under the CCIOA, including without limitation a managing agent, an attorney, or an accountant employed by the executive board. Officers most often take the titles of what you'll commonly see as HOA president, HOA secretary, or the treasurer. Your members are commonly referred to as, the homeowners in the community, or the owner or owners, unit owner, or also voting member. Typically, you understand a member to be your neighbor or your neighbors. An employee is a non-officer individual employed for the association, such as a on-site supervisor, a repair person, or perhaps a front desk or security guard. And then lastly, an agent is any individual or entity authorized by the association to provide services, such as a community association manager, an attorney, an accountant, or an engineer. So note that an employee or an agent can also be an officer of the association if appointed by the board and if provided for by the governing documents. All right, so where do we see the authority, or where is the board member authority defined in state law? Where do we see it defined? So we see it in 38 in the CCIOA, 3833.3-302, powers of unit owners association. And I'm not going to list off all the powers that you'll see in there. It's a pretty comprehensive list, but in essence, board members have the power to adopt and amend bylaws, adopt and amend budgets. They're able to hire and terminate managing agents, institute litigation, and regulate and manage the common elements of the community. The next section that we see board member authority is also in CCIOA, subsection 303. And this section kind of goes into detail about like what a board cannot do. And a couple of important things that they're not able to do is act on behalf of the association to amend the declaration. The board can also not terminate the community or determine qualifications for board members. Below there in 2B, I put, I included that if a board member is not appointed by the declarants, no member of the executive board and no officer shall be liable for actions taken or omissions made in the performance of such members' duties, except for wanton and willful acts or omissions. And I'll get more into that a little bit later as well. Also, we see board member authority outlined in the Colorado Nonprofit Act, section 7123-102. And this section kind of clarifies a board member's ability to appoint officers, as well as define their duties and fix their compensation, if any. All right, so the kind of getting into the Colorado Nonprofit Act a little more. The Colorado Nonprofit Act provides that the requirements for directors will first be defined in the HOA's Articles of Incorporation. Otherwise, the law states that a director only must be an individual and imposes no other qualifications in order to become a director. Additionally, the bylaws may prescribe other qualifications for directors. And then further, the Nonprofit Act also states that directors do not need to be a resident of Colorado or a member of the HOA unless the bylaws so prescribe. The Nonprofit Act also provides that a board of directors must consist of one or more directors, with the number stated in the bylaws. If granted by the bylaws, the voting members or the board may establish a range for the size of the board of directors by fixing a minimum and maximum amount of directors. The number within the established range may then be changed from time to time by the voting members or the board. So all directors except the initial directors, and when I say initial directors, I mean those directors that are appointed by the declarant or the developer, shall be elected and appointed in accordance with the bylaws. And the bylaws may also allow for staggered terms for directors. Boards might consider amending bylaws to allow for staggered terms to ensure that there's not any significant or large institutional knowledge void, if you will, if the board would be removed all at once. So if the treasurer's role was coming up for re-election and they resigned or were not on the board any longer, it wouldn't be as detrimental to the entire board if it was just one board director being re-elected as opposed to, say, all 3 or all 5 directors. It might also be easier to elect a new director if there's only 1 or 2 openings as opposed to 3 or 4 openings. All right, so the HOA Center, we are commonly asked about what can be done when a board member is not performing their duties satisfactorily. While mediation and dispute resolution should always be considered first, recall of the board is possible under state statute. If the board is not doing their job, or if an individual board member is violating state law or violating their governing documents, the unit owners always have an opportunity to remove their board or board member. So CCIOA section 3833.3-3038 states that notwithstanding any provision of the declaration or bylaws to the contrary, and that means that whatever might be stated in your declaration or bylaws, this section of CCIOA will automatically supersede that section. The unit owners, by a vote of 67% of all persons present and entitled to vote at any meeting of the unit owners at which a quorum is present, may remove any member of the executive board with or without cause, other than a member appointed by the declarant or a member elected pursuant to a class vote. So what does that look like? Let's discuss a hypothetical scenario in which a board member or a board could be recalled. So consider a situation or a scenario in which your community has 60 voting members. Quorum requirement is 20% per the governing documents, which means in order for a valid meeting to occur, there would need to be 12 voting members show up at this meeting. So 18 voting members show up to the meeting. Therefore, the meeting has to reach quorum and a vote to remove a board member can be taken. According to the statute, at least 12 members at the meeting need to affirmatively vote to remove the board member, in this case, 18 times 2/3 or 67%. So if 12 members vote in the affirmative, then the board member is recalled. So what does a recall meeting look like? So the first step would be to call a special meeting, which I'll explain how to do on the next slide. The next step is to ensure notice requirements for the meeting are in accordance with both your governing documents and state law. It's possible to collect enough signatures to call for a special meeting, but if the organizer doesn't provide proper notice, then the meeting can be deemed invalid. The organizer of the special meeting should also include a clear agenda to set expectations ahead of time, and also to have a system in place for issuing proxies and ballots to owners. So, a recall meeting usually is very contentious and can be awkward for a community. So it's important to adhere to the association's conduct of meetings policy to help in reducing the anticipated friction that will likely occur between members. And lastly, have in place a system for filling the vacancy that will inevitably occur should a board member be recalled. It can be kind of weird and maybe perhaps a mistake if several board members are removed and there's no other suitable individuals to fill their vacancies. So there are 3 ways to call a special meeting. The board president may call the meeting. A majority of the board can call the meeting, or 20% of all owners can request a special meeting, or any lower percentage specified in the bylaws. Note that if a petition is signed by 20% of all the owners demanding a special meeting, the meeting, and assuming that notice is properly delivered to a corporate officer, such as the president, treasurer, or secretary, and the association does not notify the community within 30 days of receipt of the demand to hold a special meeting, then a person signing the demand may set, this is according to the Nonprofit Act, may set the date and place of the meeting and give notice and subsequently give notice pursuant to the Colorado Nonprofit Act. And that's section 7/127/102. Meeting notices must be provided at least 10, but not more than 50 days before the meeting takes place. The Colorado Revised Nonprofit Act also discusses requirements for officers. First, the law provides that officer requirements will be stated in the HOA Articles of Incorporation. And unless otherwise stated in the articles, an officer must be an individual who's 18 years or older, and they must be appointed by the board. Further, all nonprofit corporations must have a president, secretary, and treasurer, unless otherwise provided for in the bylaws. And you'll find that typical in many corporations as well. Nonprofit corporations, president, secretary, and treasurer are the most common officer roles. Can an officer be removed? Yes, or depending on the governing documents. So the authority to remove an officer is found in the governing documents, but often a board is able to remove an officer from their position at the board's discretion. A board might find an officer to be in violation of their fiduciary duty, which I'll talk about here in a little bit. Additionally, a majority of the board might just feel it's appropriate to remove the official title from the offending board member while still allowing them to remain a board member with regular voting rights. This could be in a situation where there might be a lot of drama going on with titles, and or maybe you're a board member and you just don't want the drama associated with being the president. So for committees, HOAs also have the ability to create committees and disband committees. The statutory authority to form committees is found at section 303(3)(b) of CCIOA, which states that committees of an association must be appointed pursuant to the governing documents of the association, or if the governing documents are silent, or if they don't contain provisions about how to form a committee, the Colorado Nonprofit Act will control at section 7/128/206. And that section of the Nonprofit Act states that the board of directors may create one or more committees of the board and appoint one or more directors to serve on a committee. What are some common types of committees that we see in HOAs? Architectural review is likely the most common and recognized type of committee. We also see landscape committees, environmental and water use committees, safety committees, and community activities committees. That's a mouthful. Construction defects, renovation, and special projects might also be special types of committees that you'll see in your community. It's important to keep in mind that, to run a successful committee would require a charter of sorts, which would outline the purpose and characteristics of the committee. It'll define the roles of each committee member, as well as what each member is and is not allowed to do without board permission. And can a committee member be removed? The answer is typically yes, at the discretion of the board, and also in accordance with the governing documents. So what are the fiduciary duties of board members? The term fiduciary duties is thrown around quite a bit, and I think a lot of people don't understand what that means exactly. So first, what does fiduciary duty mean? Fiduciary duty means holding another individual or entity's interests over your own by virtue of authority granted. So for example, lawyers have a fiduciary duty to act in the best interest of their clients. Doctors have a fiduciary duty to care for their patients. And directors of a nonprofit corporation have a fiduciary duty to manage and protect the assets of the shareholders, put them in quotes, or the homeowners. Community associations don't have shareholders, but what's commonly known as a shareholder is a homeowner or unit owner. So what are the fiduciary duties? There's the duty of care, which is a legal notion found in corporations and nonprofit corporations alike. The duty of care is the legal obligation imposed on an individual, requiring that they exercise a reasonable standard of care while performing any acts that could foreseeably harm others. So if you're on this call and you're a board member and you're kind of wondering, I hope I'm fulfilling my duty of care, or I wonder if that decision I made, 2 months ago might have breached the duty of care. I think it's important that in fulfilling your duty of care, you should ask yourself, if you don't know something, have you asked a professional or someone who is an expert in that field? Have you read the Colorado Common Interest Ownership Act and the Colorado Revised Nonprofit Corporation Act? While I don't think you're expected to memorize and be able to legally interpret law, you should at least be familiar with it and attempt to read it and see how it might apply to your situation. Also, have you read your declaration, your bylaws, your governing documents? Have you made an effort to at least conduct due diligence when trying to run your community? It will be difficult to prove that a board member breached their fiduciary duty of care if at the time of the alleged breach, the board member exercised thoughtful and sound decision-making in their business dealings. If you have more questions about the duty of care and its legal ramifications, you should speak with an attorney. And with that, there's other fiduciary duties, including the duty of loyalty. Duty of loyalty is a term used to refer to a fiduciary's loyalty to a corporation. A board member must place their association's interests before their own. So a quick example for you here. So pretend that Nancy is a board member, and let's just say Nancy's good friend John owns a snow removal company. John wants to bid on the association's snow removal. Nancy should recuse herself from voting on the bid to avoid the perception of any conflict of interest. If there's even a slight chance that a board member could benefit personally from voting on any issue under consideration, the board member should abstain from voting. And they should take, as a board member, you should take great care in avoiding even the perception of a conflict of interest. Board members have duty of due diligence, which is, as I mentioned before, seeking out professional advice when you're unsure as a board member. For example, what I mean by that is, say maybe your declaration calls for routine maintenance on the roof or on certain electrical systems. Before making a business decision, the board should consult with a professional roofer or an electrician to help make the most informed decision possible. Lawyers, accountants, and engineers are other professionals in the HOA world who are frequently sought out for their advice. Board members also need to stay appraised of changing state laws and HOA regulations that govern their communities. Just in the past 3 years alone, I believe there's been about 24 new laws passed in Colorado that in some way, shape, or fashion affect common interest communities. There's a duty of confidentiality, which relates to records requests in your community, also executive sessions. Board members are required to restrict the access to certain documentation and information. That information should be protected. Section 7/128/401 of the Nonprofit Act requires each board member to discharge their duties in good faith with the care of an ordinary prudent person in a like position would exercise under similar circumstances and in a manner the board member reasonably believes to be in the best interests of the association. And board members have a duty to be free from conflicts of interest. And I kind of already discussed this, but in essence, section 209.5 of CCIOA states that HOA associations should have a required policy on how to handle conflicts of interest. That policy must at a minimum define or describe the circumstance under which a conflict of interest exists. It should set forth procedures to follow when a conflict of interest exists, including how and to whom the conflict of interest must be disclosed. The conflict of interest must be disclosed and whether a board member must recuse himself or herself from discussing or voting on the issue. And also the policy must provide for the periodic review of the association's conflict of interest policies, procedures, and rules and regs. The Nonprofit Act also defined, there is a definition in state law, and that definition is in the Colorado Revised Nonprofit Corporation Act, which defines a conflicting interest transaction to mean a contract, transaction, or other financial relationship between a nonprofit corporation and a director of the nonprofit corporation, or between the nonprofit corporation and a party related to a director, or between the nonprofit corporation and an entity in which a director or the nonprofit corporation is a director or officer who has a financial interest. The Nonprofit Act at Section 501 discusses procedures for how to address any potential conflicts of interest. And typically that involves disclosing the conflict to the other board members, to the members, the unit owners, or to the association as a whole. We also see business judgment rule floating around quite a bit. So what is the business judgment rule? The business judgment rule is a principle of law that courts use to evaluate director decisions in lawsuits alleging a breach of a fiduciary duty. So in evaluating director decisions, the courts typically will apply a three-pronged approach. Was the director acting in good faith? Number one. Was the director acting with the care that a reasonably prudent person would use? Number two. And then finally, with the reasonable belief that the director is acting in the best interest of the association, which is number three. These are facets that judges will typically look at. Again, I'm not a lawyer. I don't have a law degree, but they'll typically look at these notions when ruling in court cases. Again, as I previously mentioned, directors are entitled to rely on information, opinions, and reports by legal counsel, accountants, and other professionals or experts. As a volunteer board member, I don't think it's you're absolutely expected to know everything about everything in your community. For example, structural engineering issues, or what are the swimming pool pH levels supposed to be, or the fact that arborists use complicated terms to describe soil degradation. So a board member who admits that they don't know and subsequently seeks out that professional advice and follows that advice, I believe is a board member that is exercising good and sound business judgment. What could potentially constitute a breach of a fiduciary duty? Like putting your personal interests over those of the community, acting outside of your scope of authority as a board member, violating state law or the governing documents, negligently managing funds of the community, and also sowing discord or spreading false rumors about residents. While that might not be specifically defined, there is such a thing as a goodwill in communities, and I think the more or the less that the members trust you as a board member, the more likely they are to seek out ways or look for mistakes and look for any possible other breaches of duty. So it's very important to establish and build goodwill in your community. Board members should obtain proper insurance. Insurance requirements are defined in CCIOA section 313, and they include property, liability, and fidelity. Property insurance is your typical fire, hail, and flood. Liability includes slip and fall on the common elements. Fidelity will be the type of insurance that will protect against any dishonest acts by individuals entrusted with managing the association's monies. Those acts can include fraud and embezzlement. So, although not required by state statutes, but certainly recommended, are directors and officers insurance, or D&O. D&O typically covers decisions made by a board member when they're acting within the scope of their authority and in good faith. Of course, depending on the policy, it typically won't cover decisions that are just made inappropriately or without regard. Also, you have vendor insurance, which you might require vendors who are coming into your community to be insured. You can certainly ask for vendor for a copy of their insurance certificate. I've seen cases where I've read about cases where a snow plow will come into the community. They'll plow up the snow, clear the streets, but then they'll back into a unit owner's garage door, destroying their property. But they didn't have insurance, so it was kind of one big complicated mess for that particular community. So I wanted to provide a couple, board member job descriptions. I think it's important that these aren't statutorily defined job descriptions, and they will vary by community, but I did want to give you something nonetheless. So starting with HOA president, typically, the HOA president is the leader of the board of directors and is responsible for scheduling, attending, and leading board member meetings. This individual enters into contracts with vendors and agents and holds the power to call special meetings. The president spearheads the enforcement of covenants and rules and regs that are adopted by the board of directors. And of course, I forgot to mention on this slide, but presidents also have the ability to appoint committees most of the time, according to the governing documents. So the HOA vice president will support the president in his or her duties when they're absent or otherwise unavailable. They should be prepared to perform the same duties as the president and be equally comfortable leading meetings and making those sound business decisions that we discussed earlier. The HOA, let me go back a slide here. I was going to mention, so the HOA vice president, this is not a required officer position according to the Nonprofit Act. Remember that typically the only officer positions that are required are the president, the secretary, and the treasurer. So the HOA secretary, in my opinion, I think the HOA secretary is the most important role you'll find on a board of directors and is often the most difficult to fill because the secretary is in charge of preparing and maintaining meeting minutes and keeps association records organized. This person will ensure the HOA is in compliance with its bylaws and provide access to association records by its owners. They're essentially a gatekeeper of records, information, and all the many other important areas of HOA life. And then last but definitely not least, the HOA treasurer is the financial custodian of the community. They're in charge of managing the HOA's monies, as well as keeping proper accounting records of receipts and expenditures of the HOA's books. This person tracks the overall financial condition of the organization and likely will be involved with any lending activities with financial institutions. The treasurer has the very important job of coordinating the annual budgetary process. They will prepare annual financial reports and oversee any audit reviews requested by the board or unit owners. One tip for the treasurer is, although you'll see a lot of communities managed by a professional community manager and also the bank accounts. But it's also a good idea for the treasurer to exercise practice caution, just to check the bank accounts and make sure that the records match up with the information given. Not to suggest that all community managers are bad or commit fraud, but it's always good practice just to double check the records and reconcile the bank accounts. All right, well, that concludes my presentation. I hope you all learned a thing or two about basic board member rights and responsibilities. Let's see if we have time here to answer any questions or if any questions remain unanswered. David, we got anything in there? Or?
A flurry of them that have come in just recently here. And I'm trying to answer some of them as we're working through here. But here's one for you, Nick. Boards rely a lot on community management companies. What protections are there on competency and management of management companies? So if you maybe take a minute to talk about the status of any CAM licensure or anything of that sort, maybe.
Yeah, well, so currently there is no licensing or regulation of community association managers in the state of Colorado. With that being said, it still falls on the board to, like I mentioned in one of my slides, to oversee the actions of the manager. Community managers operate with the board according to a written contractual agreement, or at least they should. So if you're a homeowner and you think the manager is acting out of authority or not acting appropriately, I would say your first course of action is to go to your board members, go to your board and discuss your concern with them directly. If possible, put it into writing, and give your board an opportunity to rectify the issue or at least to address the issue with the manager. A lot of community management contracts have a termination clause at the end, which should describe how a relationship will be terminated with the association in the event of one party not fulfilling their side of the contract. If you're a board member and you're maybe in this situation, I think it might be a good idea to speak with an attorney on the matter, so you can more fully understand the contractual obligations of the association.
Thank you, Nick. I'll field this one real quick. I'm not going to read the whole question, but essentially, it comes down to this homeowner has some issues. They've reached out to the property manager, and the property manager is not sharing the name of who the board members are or when they meet, and will not return any of their emails or phone calls when they request this information. So. I think that it's important to point out in response to this question that the Colorado Common Interest Ownership Act, CCIOA, requires that certain records of the association be maintained. And Nick had mentioned in the presentation here the records retention requirements in CCIOA, which are found in subsection 317. One of those is in fact the names and email addresses of all of the board members. That is a requirement by within CCIOA that that information be maintained by the board or the property manager, by the association, maybe I'll say it that way, and needs to be shared with any unit owner upon request. Now, we oftentimes include an important disclaimer there. There is not a requirement that I have to give, if I'm on the board, that I have to give my personal email address or my my work email address, something like that. I can go create board member at abchoa at gmail.com, and that can be my email contact. They could also establish an email address being the representative from the association. That is permissible, but they do have to provide the identity of the board members as well as an email address for them. Again, that's section 38-33.3-317, the records requirements within CCIOA. Nick, a question for you is a concern about if it's acceptable or not for HOA financials to be months behind, as nothing to date, with July 24 being the most recent provided in this attendee's example.
Sorry, David, can you repeat that question? I know I heard.
If it's acceptable for HOA financials to really be months behind or not. Essentially, I mean, my take on that is that if your bylaws expressly state that that monthly financials will be provided to unit owners or posted on a website or made available, then the association does need to comply with what your governing documents say. However, it's more common that when you see those types of requirements, that in fact they're going to be more like quarterly. There are annual requirements, annual financial disclosures that are required by the association to every homeowner each year. That's very important as well. But requesting that information, again, pursuant to the same section that I mentioned a moment ago, subsection 317, is it's in order to obtain the latest and most up-to-date financials would be what my recommendation would be in regards to obtaining financials.
Yeah, thanks, David. I was trying to look at some of the questions too at the same time, so it was a little tricky. I do see a question here. What laws do we fall under if our HOA was incorporated in 1982? So I believe that would be the Condominium Ownership Act, which was replaced by the CCIOA. Also, your community likely will probably be subject to only certain portions of CCIOA. I think it's section 116, 3833.3, 116 of CCIOA that discusses pre-CCIOA communities and what sections are applicable to those communities. So in addition to the Condominium Ownership Act, your community will be subject to of course, the provisions in your governing documents. And I believe also that the David, correct me if I'm wrong, but I think the Colorado Nonprofit Corporation Act also applies to pre-Kiowa communities.
It
Correct?
absolutely
Correct.
does, yes.
Yeah.
Particularly where in circumstances where where Kiowa states utilizes certain language that will defer back to to the Nonprofit Act. That is correct. But yes, both the Condominium Act in certain cases, but also the Nonprofit Act. And again, and you may have said this, the main principal reason for that is because your associations are all identified under Colorado law as corporations. You have a Secretary of State filing, you have articles of incorporation. Now, most commonly, associations are nonprofit corporations, and that's why the Colorado Nonprofit Corporation Act is what controls in these situations. But yes, so that's both both Kiowa as well as the Colorado Nonprofit Corporation Act can be located on our website, which is found most easily by looking at the slide. Actually, I believe. No, I just going to dre.colorado.gov and then selecting the HOA Center, you'll be able to access the most current up-to-date laws. In addition to that, and someone asked this question, is why I'm going into some detail on it, is we also on an annual basis after the annual legislative sessions are completed and laws have been signed and by the governor and whatnot. Our office does provide legislative summaries, HOA forms, as well as some written summaries that can also be located on our website. That's a great place to follow the latest and greatest of what's happening in the legal world, at least with respects to HOAs.
Yeah, there's another question. I'm not sure I understand, but somebody asked, do we need specific personal liability coverage insurance? I think they're asking that as a board member. So insurance for your community will be, the requirements are found in Kiowa, section 313, I believe, as well as any insurance requirements stated in your declaration or covenants, conditions, and restrictions. So I'm not entirely sure what you mean by personal liability coverage. But if that's something that is of concern to you, I think having a conversation with your real estate broker would probably be prudent.
Here's a question. Our original declaration still has the original builder as the declarant. How do we change the document now that we have units completed and he or she is no longer involved in the association? The Colorado Common Interest Ownership Act has a process by which the transfer of control from the declarant to the unit owners takes place. If for some reason, essentially as the declarant sells more of those units or units are built out and whatnot, the authority to run the association is transferred to the unit owners. Nevertheless, if you felt that it was important to remove that history for some reason, once the declarant's no longer in control, they're not. I mean, yes, they are still the declarant, but they don't have the authority to do anything at that point. So there's not a whole lot of reason, at least in circumstances that I can consider, that you need to remove that history from your governing documents. However, if you did choose to do so, Kiowa does offer a process by which to amend your declarations, and you can change your governing documents. It is costly, it is timely, or takes a long time, time consuming, and it also, most importantly, requires a significant amount of buy-in from your community. Usually in most communities, somewhere between 50% and 67% of your community need to be in favor of the changes. So amending one's declaration can be challenging. However, associations do it all the time. But you might want to consider discussing that with council to see if it's worthwhile to pursue that, just because in order to, in this case, simply to remove someone, the name of someone in there, again, because you in this scenario we don't have the declarant exerting any authority or control, because it sounds like the situation's been transferred over to the actual unit owners.
There's a question here in the case of damage to units from common areas, i.e. roof leaks, common plumbing, etc., are there laws that specify what the HOA is responsible for versus what the unit owners are responsible for? Or is that only in the HOA governing docs? So there is a section in CCIOA, I believe it's in the maintenance section, that describes when the association is responsible for, I believe it says, timely repair of the unit owner's property. I believe it's section 317 for maintenance. I don't have CCIOA in front of me, so I apologize if I'm misquoting some of these citations, but it's in the maintenance section, and it does describe when the association must be responsible for prompt repair in those circumstances. How do we find out if our HOA is a nonprofit? That should probably be answered in your articles of incorporation. You can look those up by going to the Colorado Secretary of State's website and searching for your association legal name. I think in most cases, I believe the articles will state whether it's a nonprofit corporation.
One more question here that I think bears an answer here is, where'd it go? Is it reasonable for a board member to restrict owners at a monthly board meeting to talk for a limited time so that board issues can be discussed at board meetings? The first and foremost place to start with this is look at your association's governance policy called the Conduct of Meetings policy. This is a required governance policy. Commonly, in order for purpose, I mean, different communities have different needs and abilities to do this. If we're talking about an 8,000 unit association and there are 400 people that come and want to talk at a meeting, even 3 minutes might be a long time to grant to everyone. But in an association that has 10 people, maybe 5 minutes or even longer could be appropriate. But what's important is that each association have a conduct of meetings policy set forth. And not only the duration of how long public comment can take, but also some other issues that are really worth considering, such as such as decorum and identifying what a quorum is, decorum and quorum. There, sorry to throw those two words so close to one another. But a conduct of meetings policy will help do that and also help manage the expectations both for the board members as well as for all of the unit owners that come to a board meeting and would like to express their thoughts or concerns or ask questions, etc.
Could you please review the issue of changing declarations, bylaws, etc.? Is it 67% of the quorum or 67% of all members? I think we're going to do a HOA forum on amending HOA governing documents here soon. So stay tuned for that announcement. Do I need to register our HOA with the state of Colorado? So that requirement is found in CCIOA, section 401. It can be a little confusing to read, but in general, most if not all associations must register with the Colorado Division of Real Estate. When I say that, I think it's probably a good rule of thumb if your community collects assessments from its members, then it should register with DORA, the Division of Real Estate. Let's see, maybe time for one more question.
Here's a question. Can a person not listed on the deed of trust serve on the director's board if they are married to a person on the deed? That depends. That very much depends on the governing documents of any association. Commonly, although Colorado law only requires that you be an individual human being in order to be on a board of directors, some associations have additional restrictions or requirements, if you will, such as you must be on the deed, or you must be a resident here, you must be an owner of the association or within the association in order to serve, whether as a board of director member or as an officer. So in order to answer that question, you'll need to review your governing documents.
All right, let's see here. Okay, so thanks everybody again for joining. I also wanted to thank you, David, for also being on the call and lending us your HOA expertise. It's always a pleasure having you, and also thanks Amanda for helping out. This concludes our presentation, and I hope everybody has a very safe and enjoyable holiday season. And again, if we weren't able to answer your questions this time around, please feel free to shoot us an email. All right. Thanks again, everybody, and have a great weekend. Bye-bye.